Hello, everyone. I'm Derek Teeter, a partner in Husch Blackwell's education group. Thank you for joining our webinar today. Before we begin, we have just a few housekeeping items to go over. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, please submit via the question box. We will try our best to answer all the questions that you are submitting to us, but if something requires a fuller answer or we run out of time, we'll try to follow up with you by email. A PDF of the presentation is available in the program materials folder. This program has been approved for legal education hours. To report those hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Toward the end of the program, be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. So let me introduce now my co-presenter, who is Claire Hawley. Claire brings an observer's keen eye and insight to solve problems for clients. After her undergraduate years, she earned a grant to work with the Illinois Network of Charter Schools and worked with the legal team there. Her early success in that position opened her eyes to the power of the law to make real change happen for people. In law school, Claire found herself drawn to the research and writing involved in the practice of law. And today she views every legal challenge for her clients in higher education as a complex puzzle to be solved. And certainly the intersection of employee speech and religious freedom is a complex puzzle to be solved. So looking forward to presenting with Claire today. Okay, one last thing from me before I turn it over to Claire is just to briefly go over our agenda. We're going to start by talking about the freedom of speech and some of the key principles that underlie it, including some special rules for employee speech at public institutions and academic freedom. And then we'll transition into talking about religious freedom itself, some of the different elements of the religious freedom clauses in the First Amendment, and some special statutory protections for religious freedom. And throughout the presentation, we're going to tie in some cases and scenarios that bring together both of these concepts and show you the complexity there and how the courts are grappling with this. So with that, I'm going to turn it over to Claire to walk us through the first portion of the webinar.
Thanks, Derek. Hi, everyone. I'm Claire, and I'm going to kick it off by talking about the First Amendment. So there's probably no better place to start than the text of the amendment itself, which says that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press or the right of the people peaceably to assemble and to petition the government for a redress of grievances. So seems simple enough. We'll see if that bears out. So as an initial matter, the First Amendment only applies to government actors. It's going to restrict the actions of federal, state, and local governments. So this will include state and municipal universities, community colleges, state-operated career and technical schools, and K-12 public school districts. Private institutions, on the other hand, are governed by their policies and their contracts, and in some instances, state law. So some key concepts. The First Amendment reflects the values of truth, self-governance, and individual freedom, which the framers viewed as essential to democracy. So if you don't have the First Amendment, it begs the question of who gets to decide what speech is and isn't allowed. And the framers didn't want to vest that authority in the government. So the First Amendment is fundamentally a question of who decides. It protects all forms of expressive conduct, so not just verbal and written speech. Expressive conduct can include art. It can include black armbands worn by students in protest of a war, or burning the American flag, for example. And speech is only one protected category. As I noted earlier, it also protects freedom of religion, assembly, press, and petition. So not all speech is protected equally under the First Amendment. You won't find a court decision articulating this hierarchy that's on the slide, but courts acknowledge that certain speech is more protected than others. When you look at how courts resolve cases, they will jealously protect religious and political speech, and there's still a lot of protection given to matters of speech on matters of public concern. And then courts will allow more restriction on speech in less protected categories, like petty speech on individualized grievances, or speech of government or public employees, or commercial speech. And then there's some speech that gets no protection at all. So here are those pretty narrow categories. Incitement is a statement directed at producing imminent lawless action, and it's likely to do so. Courts will use the clear and present danger test to determine if a statement is in fact incitement. And then there's fighting words, which by their very utterance, they inflict injury or tend to incite an immediate breach of the peace. And then there are criminal threats. These are statements that frighten or intimidate one or more people into believing that they're going to be seriously harmed by the speaker or someone who's acting at the speaker's behest. These are true criminal threats. So jokes or hyperbole, those don't qualify. Defamation, these are false statements of fact harming another's reputation. And there are two forms, slander and libel. And then finally, there's obscenity, which is a narrow category of pornography that violates contemporary community standards and has no serious literary, artistic, political, or scientific value. This is a really limited category that generally only applies to absolutely abhorrent content, like, for example, child sexual assault material. And then as a final point, just to be clear, offensive speech or hate speech, they're not synonymous with any of these categories. Much of the speech that is protected by the First Amendment is in fact offensive and in some cases hateful. So here are some general principles of government regulation of speech. First and foremost, the government is rarely ever allowed to discriminate based on viewpoint. They can regulate based on content, but they have to satisfy strict scrutiny. And so the difference between those two, if you regulate based on subject matter, that's content-based regulation. If you regulate based on the message, that's viewpoint-based. So a law that says nobody can have political signs in their yard, that's content-based. But a law that says nobody can have signs supporting a libertarian candidate in their yard, that's viewpoint-based. And then in certain settings, which we call forums, the government can limit the subject matters to be discussed by category, and it can also impose reasonable time, place, and manner restrictions. So restrictions on how loud the speech is or what time of day the speech occurs. There are traditional public forums like streets, sidewalks, parks. Those are where individuals have the greatest free speech rights. But then there are a lot of places, even on public universities, where the forum isn't a traditional public forum and the government does have more right to regulate speech. So for an example, a classroom, that's a limited forum, if not a closed forum. But at the same time, many courts acknowledge an exception in that forum for faculty speech, which we'll discuss in the academic freedom slides later on. So Pickering and Garcetti are the leading Supreme Court cases on government employee speech. And critical to understanding both of these cases is the fact that the government as an employer has the right to speak too. In order to function effectively and do what it needs to do, the government has to be able to convey messages. And one of the main ways that it is able to do this is through its employees. So this creates an interesting scenario, sometimes a little bit of tension between employees who have First Amendment rights as private citizens, but who are also being paid to speak by the government. The government needs greater control in that situation, or it could never have a coherent message. So Pickering is the early balancing test. It essentially requires balancing the interest of the public employee as a citizen in commenting on matters of public concern against the interests of the state as an employer in promoting the efficiency of the public services it performs through those employees. And in the later case, Garcetti, the court held that when public employees make statements pursuant to their official duties, they are not speaking as citizens under the First Amendment. The Constitution does not insulate their communications from discipline. So here is the framework taking Garcetti and Pickering together for the regulation of government employee speech. So as a general matter, a public employee's speech will be protected if it is on a matter of public concern, it is not made pursuant to their official duties, and their First Amendment interests outweigh the government's legitimate interests in efficient administration. So one threshold question that comes up a lot is, when is speech a matter of public concern? And this is a fact-intensive analysis that depends a lot on the context and the timing and the manner of the speech. But as a general rule, a speech is on a matter of public concern when it can be fairly considered as relating to any matter of political, social, or other concern to the community, or when it is a subject of legitimate news interest. So Kennedy v. Bremerton, this is a recent SCOTUS case. You may have heard of it. It's often primarily described as a religious freedom case, and it is that, but it also has an important free speech element, which is whether Garcetti applied. So Joseph Kennedy, he was a football coach at a public high school in Washington, and he's also a devout Christian. And he had a practice at the end of every game. He would go to midfield and he would kneel, as he is in the photo, for about 30 seconds, and he would say a prayer, usually silent. But he was in full view of players and spectators. The school told Kennedy to avoid demonstrative religious activity in view of students, but he continued to pray at the end of games, and he was placed on administrative leave. When this made it to the Supreme Court, the court held that Kennedy's prayers were not part of his official duties as a coach, and therefore the school violated his free speech rights. So this case is really interesting because it places two key constitutional principles kind of on a collision course. So the free speech clause protects private religious speech, as we've talked about. The Establishment Clause, which Derek is going to talk about much more later on, that prohibits the government, including public schools, from conveying a preference for a particular religion, which was the position the school took in Bremerton and Kennedy v. Bremerton, basically that by allowing a coach to play, it created the appearance that the school supported the display of religion. The Supreme Court disagreed. And then this is another case. This is a Sixth Circuit decision that indicates that there is an academic freedom exception to Garcetti. So faculty at public universities, some courts acknowledge that they have a unique First Amendment right that gives them considerable discretion as to how they speak in the context of teaching, writing, things like that. This is not true for other employees, even public employees who are more constricted under Garcetti. So in Meriwether v. Hartop, it was a professor at a public college refused to refer to transgender students by their preferred pronouns because it violated his religious beliefs. The college had a policy requiring employees to do that. The professor had at least one transgender student in his course and misgendered the student on at least a couple occasions, prompting the student to report to college administration, who then gave the professor a written reprimand. The professor sued, and the Sixth Circuit held that the professor plausibly alleged that the college violated the First Amendment. The court said, the academic freedom exception to Garcetti covers all classroom speech related to matters of public concern, whether that speech is germane to the contents of the lecture or not. So the professor's use of pronouns was a matter of public concern. And part of this decision, it hinged on the fact that the faculty member had a First Amendment right to speak in the way that he wanted to speak in the classroom, regardless of his employer's dictate. So academic freedom was originally understood as a professional norm that emphasized the protection of individual faculty autonomy over institutional interference. A professor's speech is the lifeblood of their work in many ways. It's how they communicate their ideas and their research to the world. But the institution that they work for also has a property interest in that speech because they pay for it, they make it possible. In the mid-20th century, the Supreme Court started establishing kind of what some might call a jurisprudence. It's fairly thin, but specific to academic freedom within the broader context of the First Amendment. So here are a few quotes from those opinions. We won't go into them too much because in many ways they're dicta. One is even from a plurality opinion. They just kind of emphasize that the Supreme Court has recognized that this is a unique context for the First Amendment, but they haven't necessarily laid down any specific dictates. So the Garcetti majority didn't address how its rule applied to speech related to scholarship or teaching, but they noted that there may be, quote unquote, additional constitutional interests in that context. So Garcetti essentially left it up to appellate courts to define the scope of a professor's official duties under the First Amendment. On the slide, you'll see the quotes from Garcetti where the dissent raises the issue of how will this apply in a classroom context to faculty, and the majority essentially sidesteps that issue. So courts have been generally reluctant to recognize academic freedom rights in a K-12 setting as compared to higher ed. So the cases where academic freedom is upheld against Garcetti are almost always in the higher education setting. So this slide, it frames it kind of as a circuit split, and there still isn't really a unified consensus on academic freedom in the various categories listed on the slide, but the split is really more a product of the differential treatment between K-12 and higher ed. So when college professors are writing, teaching, and researching, it's very likely that the academic freedom exception will apply. But in the K-12 setting, states have mandatory curricula. So they have the need to dictate how subjects are taught. There aren't those kind of mandatory standards in higher ed. So that's kind of what's driving the differential treatment. Okay, and now we've gone over a lot of principles, and now we're going to try to apply them to a couple scenarios. So here's one scenario, and this is based on a recent case, actually. So an art history professor at a private university shows images of the Prophet Muhammad during an Islamic art unit. Aware that such images may offend some Muslims, the professor warned students in the syllabus. The professor showed 2 images in class, and a Muslim student complained. The professor apologized privately to the student and to the class as a whole. Then the Muslim Student Association called for the professor to resign. Administrators criticized the professor in media statements and university-wide emails, and then the professor's part-time contract was not renewed. So the question here is whether the university violated the professor's First Amendment rights. And so here we have the poll. The answers are A, yes, B, no, and C, I don't know. So go ahead and put your answer in the chat, and it's totally okay to guess. All answers are anonymous. We'll just wait till we have a critical mass. And remember, this is a private university. The professor is not Muslim, showing images that certain people who are Muslim believe to be offensive. Okay, we'll go ahead and end the poll, check the results. Okay, so about 60.1% people said yes, about 28% said no, and about 12% said I don't know. So full disclosure, this is a little bit of a trick question because this is a private university. So the First Amendment doesn't really apply at all. But the faculty members sued under a state statute, specifically the Minnesota Human Rights Act, which prohibits religious discrimination in a very similar way to the First Amendment. So while no can't be the right answer because this is a private employer, that doesn't mean that there isn't potential legal risk here for private colleges and universities. So this is an example of a reverse discrimination claim under state law. So this is the case that this scenario is based on. The federal district court denied Hamline University's motion to dismiss. So the court said that the professor plausibly stated a claim of religious discrimination under 2 new theories. First, that she was discriminated against because she was not Muslim, or that she was discriminated against because she failed to conform to certain religious views of others, specifically that it is improper to depict or view images of the Prophet Muhammad. And now we have our second scenario. So here we have Professor Z, who he teaches economics at a large public university, and his research exclusively focuses on Keynesian macroeconomic theory. And don't worry, you don't need any background in econ to answer this hypo. The chair prefers microeconomics. The chair of the economics department prefers a different style of economics, and he openly calls Keynes outdated. Professor Z applied for 3 promotions in the department over 3 years, but he's never even interviewed. The chair instead hired younger scholars who specialize in his preferred modern microeconomics. When Professor Z approached the chair and asked, why am I not even getting interviewed? The chair says, you simply don't have the ability to teach and conduct research in modern economics. Your work isn't synergized with the department's research agenda. No Keynesian will ever make tenure while I'm chair. The chair also reassigned Professor Z from Intro to Macroeconomics, his most popular course, and gave the course to one of the newly hired professors, who, as mentioned, focuses in microeconomics. So did the university here violate Professor Z's First Amendment rights? And the answers are A, yes, B, no, or C, I don't know. And this is not a trick question. This is a public university. The First Amendment does apply. And this is a professor who is not getting promoted and getting reassigned from courses because of the methodology that he employs in his research. Okay, we have a little over 53%. Let's go and see the answers. So about 21% said yes. About 67.5 said no, and about 11% said I don't know. So the majority is correct here. So this case is based on Heim v. Daniel. It's a Second Circuit case, and the university won on summary judgment. So in that case, the court held that a public university's interest in deciding for itself what skills, expertise, and academic perspectives it wishes to prioritize in its hiring and staffing decisions outweighed the professor's asserted interest in competing for those positions unencumbered by the chair's assessment of his approach or methodology. So this case is important because it shows that public institutions in some instances can discriminate based on the content of employee speech. So it was totally permissible for the chair to say, I don't like Keynesian economics, and because that is relevant to assessing that faculty member's qualifications for employment and promotion. So that concludes our discussion of free speech. Thank you all for being so attentive and engaged. I'm going to pass it to Derek to talk about religious liberty.
Okay, well, thank you, Claire. And I see folks are chatting in a lot of great questions. We're going to save some time at the end of today to kind of go through those so that you're not being ignored, but we want to make sure we get through the content that we have on tap before we engage on those points. So transitioning to the religious freedom aspect of this. So thinking back to that first slide that Claire showed you, the First Amendment covers a number of things, and freedom of speech is one of those, but it also has clauses that address the idea of religion. Principally, the clause that says Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. So the courts actually split this sentence into two different ideas. We call the first part the establishment clause. Congress can't make laws establishing religion. And then we call the back half the free exercise clause. Congress can't make laws prohibiting the free exercise of religion. And so in the same way that the First Amendment free speech clause applies to governmental actors, so is it the case that these religion clauses only apply to governmental actors. They originally only applied to the federal government, but after the Civil War, when the 14th Amendment was adopted, it applied all of these First Amendment principles to other forms of government, states and municipalities. So we're talking really about limitations here on public institutions, at least as far as the First Amendment to the Constitution goes. Some of the religious liberty principles in statutes apply more broadly to both governmental and private institutions and employers. Okay, so we need to break this apart and talk first about the Establishment Clause and then talk about the Free Exercise Clause, because both of them affect how we think about employee speech rights and speech about religion. Okay, so the Establishment Clause, broadly speaking, is a limitation on the ability of the government to take certain actions that would favor or advance religion. And really until the last couple of years, there was a very elaborate and complicated Supreme Court test called the Lemon Test that helped guide how we thought about when government went too far in involving itself in religion. And without spending too much time on that, we can say that this Lemon Test is no longer the law. The current Supreme Court has essentially eliminated it, viewed it as overly restrictive and overly complicated, and is trying to take Establishment Clause case law sort of back to a historic analog. So what can we say today? Well, first we can say the government can't take actions where the sole purpose of the action is to advance religion, except sort of narrow historical exceptions, like maybe having, an invocation at the beginning of Congress, because that's something we've always done. The government also can't mandate or coerce participation in religious practice. The government can't pick and choose a preference for certain religious denominations. But at the same time, religious entities can benefit from governmental programs that are generally open. And we can't have excessive entanglement in the sense that we don't want the government sort of dictating how religious organizations function or trying to determine what are or are not permissible or orthodox religious beliefs. So view that establishment clause as limiting the government's ability to advance and involve itself in religion. And of course, the way that the government would do that is by individual governmental employees taking certain actions. So if you think back to that Kennedy case that Claire was talking about, where you had a coach, governmental employee, who was engaging in prayer after a game, there's a question there. Was that coach acting in a way that coerced or forced other people to pray, or was he acting in a way that was not coercive or mandatory? And that pulls in the establishment clause. And the outcome of that case could have been different if that coach had issued a rule to the team saying, you are required to pray with me after the game. Then we probably would have had an establishment clause problem, and the school probably would have been justified in limiting that practice. But those weren't the facts of the case. Okay, so that's the establishment clause. You can see how that could be a justification for a school to say to certain employees, no, you can't engage in this speech because it would cause us to violate the establishment clause. Your speech is a form of coercing people to pray, and we can't do that as a government. Therefore, you can't do that as an employee. Therefore, we can restrict you from engaging in that behavior. Okay, here's a question for you with a poll. Let's suppose we have a Catholic faculty member at a state university who keeps a photograph of the Pope on the wall in the faculty member's office. And other faculty members keep a host of secular posters, photos, art pieces on their walls. But some students see the photograph when they visit the faculty member for office hours, the photograph of the Pope. And the question is, does that violate the establishment clause? The fact that students come in to an office setting and see this religious figure on the wall. What do you think? It's a simple yes or no here. We're not going to give you kind of an easy way out. So go ahead and pick your answer. I'll give you just a moment to do that. And you just click the screen. There's no pop-up box here, so you can just click on the slide itself what you think the best answer would be. Okay, so go ahead and populate this. Okay, so overwhelming majority of you say no, that does not violate the establishment clause. And I think that's the right answer here. And so the question would be, do we have some element of coercion, some mandatory attempt to force students to be Catholic or to agree with the Pope's teachings? Or is this just sort of an expression of the faculty member's own preference, sort of in a setting where people would expect to have their personal effects? And it's really that latter view. And the fact that the school allows faculty members to keep a whole host of different things on their walls that are unique to them simply reinforces that this is not official sort of university speech that's trying to mandate religion. Okay, so this is then a great transition into the second aspect of the religion clauses, which is the free exercise. So the government can't establish a religion, it can't force religion on people. At the same time, it can't take actions that infringe the free exercise of religion. But of course, there are rules about, exactly what do we mean there. And sort of the definitive case that we are still operating under is a case called Employment Division versus Smith. And the Supreme Court in that case was sort of faced with this question. Okay, we have lots of laws in this country that are enacted for secular purposes, and yet sometimes they might limit things that a person would do for religious reasons. There are laws, for example, that ban the trafficking in eagle feathers, and yet for certain Native American religions, the possession of eagle feathers in religious ceremonies is something important. Or in Employment Division versus Smith, you had a question about whether an employee could be punished because they smoked peyote, a prohibited drug, as part of a religious ceremony. And what the court held in Smith was, look, as long as there is a generally applicable, religiously neutral law, it can impose an incidental burden on religion as long as there's a rational basis. So if the government bans drugs because drugs are bad and they result in terrible health effects, and that has an incidental effect of prohibiting someone from using drugs in a religious ceremony, Smith says that is constitutionally permissible. That doesn't violate the free exercise clause. But the government can't pass laws or take actions that specifically target the free exercise of religion. So the difference there would be if we had a law that said no one can use illegal drugs. That's neutral and generally applicable. But a targeting law would say no one can use illegal drugs in a religious ceremony. Those targeting laws are subject to strict scrutiny, which is essentially the court saying this probably violates a constitutional right. You have to really convince us you have a compelling reason to do it. And you have to have chosen the least restrictive means, the narrowest possible means of satisfying that interest that you say is so compelling. Another aspect of free exercise jurisprudence is if you do have some broad, sort of neutrally applicable law, but the government makes exceptions for various secular reasons, then it also has to be willing to make exceptions for comparable religious reasons. One way to think about that is this is sort of like a most favored nations type of analogy. It's saying that a religious justification is going to be just as important as any other justification in getting an exception from a law that would otherwise apply. Okay, so let's kind of start playing with these concepts then in the context of some specific cases. So one of the areas where we're starting to see a great deal of litigation on the First Amendment and free exercise is in the space where we're talking about preferred or chosen name and pronoun policies. We're seeing this both in the K-12 setting and in the higher ed setting, like in the Merriweather case. So there's a case that just came out of a federal court in California just a few months ago called Mirabelli versus Olson. And you had a school district, a K-12 school district, adopting a protocol that said teachers are not allowed to disclose a student's gender identity or their use of a chosen name or chosen pronouns to parents unless the child consents. And you had a group of teachers who said, well, wait a minute, we have a religious belief that we should be honest with parents and not be deceptive in our communications with them. And we think that it violates that belief for us to be calling a student one thing at school, but then when we talk to their parents using a different name or different pronouns and not revealing the fact that there's a discordance there. So the teachers sued, asserting both that they had sort of a traditional freedom of speech right not to be compelled or prohibited from speaking in a certain way. And they also said this law burdens our free exercise of religion. We have this religious belief in honesty, and this rule, this protocol from the school is forcing us to violate our own scruples. And the trial court held that this rule was not a generally applicable one because it only applied to teachers, and also because there were certain secular exceptions baked into it. There weren't religious exceptions. And so the court said, okay, it's subject to strict scrutiny. The school's got to demonstrate a compelling reason why it has this protocol, and it's got to have the most narrowly tailored means possible to address it. And essentially, the school made a couple of arguments. One, we have a sort of general interest in protecting students from, being harassed or abused by parents who may be unsupportive of gender identity. And the court said, yeah, that's really broadly formulated. I can get how maybe if you had a particularized concern that a particular student might be subject to that, but that's not what you enacted. And then the district also said, well, we have an interest in protecting the privacy of students, and so that's sufficient to support the rule. But the court said it's not, because at least in the court's construct, parents have a constitutional right to be involved in the care and upbringing of their children, which sort of overrides the stated interest of the district, which meant then in the end that these religious liberty claims prevailed. The government was not able to show in this case a compelling interest that overrode that burden on religion. Now, this case is on appeal to the Ninth Circuit. It's relatively new. We'll see how the Court of Appeals deals with it. And this is just one example of a number of different cases throughout the country where this very issue is sort of percolating up through the district courts. And we're getting different decisions from different courts, and probably these issues will find their way to the Supreme Court at some point in time and have to be resolved there. Okay, so separate and apart from these constitutional principles, there are a group of state statutes called Religious Freedom Restoration Acts, and not every state has one, but many states do. These are state laws that were enacted as a response to the Supreme Court's decision in Employment Division versus Smith. A lot of states sort of chafed at that decision and said, wait a minute, this is overriding religious liberty in a way that we're not comfortable with. And so you had a lot of states pass laws that essentially say, when our state agencies burden religion, even though the Constitution might not require them to meet strict scrutiny in every case, as a matter of state law, we will require them to demonstrate that they have a compelling reason to overcome that religious belief or practice, and that they're using the least restrictive means. So it's basically a way of imposing strict scrutiny on any burden of religion, even if it's from a neutrally applicable law or rule. And that applies at the state level if your state happens to be one that has a RFRA, a Religious Freedom Restoration Act. So that's important for you to know if you work at a public university. If you have one of these state laws, it essentially adds a more heightened degree of scrutiny to a public employer's attempts to restrict religious practice, which includes the verbalization of certain religious beliefs at times. In addition, we have a federal civil rights law called Title VII that regulates discrimination based on a number of protected statuses, race, national origin, and religion, among others. And Title VII applies to both public and private employers, so both public and private universities and colleges. And with regard to religion, Title VII does two things. One, it prohibits what I'll call classic discrimination based on adverse treatment. So you can't refuse to hire someone because they are of a given religion. But it also requires efforts to reasonably accommodate religious practice, which is a separate construct. And some religious practice involves the verbalization of religious belief or religious speech. And so that ties into this whole sort of tangled ball of legal principles that we have. So Title VII prohibits adverse treatment discrimination based on religion, meaning generally speaking, you can't refuse to hire someone, you can't fire someone, you can't demote someone, you can't deny them a raise because they are religious or because they are of a certain religion or because they aren't religious. So where religion is the motivating factor in that adverse treatment, Title VII would prohibit that. So you could come up with an example where the reason why you learned an employee was religious is because they said so. And then if they were demoted by a supervisor who had animus towards their religious status, that would be a violation of Title VII. The accommodation principle is where we do see a little bit sort of more action, more scenarios in dealing with religious motivated speech. So apart from the obligation to avoid adverse action, Title VII would say, where an employer's sort of general expectations of employees conflict with, burden the religious beliefs or practice of an employee, then that employer has to accommodate that religious belief or practice unless doing so would impose an undue hardship on the employer. And it used to be the case until this last summer that an undue hardship was a very sort of easy threshold for employers to meet. There were cases that said, look, if it's more than a de minimis burden, that's an undue hardship. And, a lot of accommodation is more than de minimis. So under that old law, it was easier for an employer to deny an accommodation for a religious person. But the Supreme Court, in a case involving a postal worker, said, no, an undue hardship is not just more than a de minimis burden. It has to be excessive. It has to be unjustifiable. It has to be something that imposes substantial increased costs in light of the size and particular nature of an employer's business. So today, it's going to be more challenging for an employer not to accommodate religious belief or practice because the test has gotten more rigorous. Okay, so another case where then a lot of these concepts get tied together is one from 2016 called Faulkner versus the University of Cincinnati. So this is a really interesting case that pulls in about everything we've talked about today. You had a plaintiff who was a non-faculty administrator at a public university, and he was asked to conduct a talk on servant leadership. So as part of his job duties, he was asked if he would conduct this talk on the idea of servant leadership. He agreed after some reticence. And as part of his talk, he referenced the Bible and some Christian principles and the fact that he was a Christian. And after the talk, it prompted a complaint to the university's non-discrimination office by someone who was offended at having to listen to biblical references and sort of articulations of this person's Christian beliefs in the context of this lecture on servant leadership. And so the plaintiff was investigated by the institution, and eventually the school concluded that he had violated non-discrimination and anti-harassment policies by injecting religion into the lecture in a way that was offensive to certain members of the audience. And as a consequence of that finding, the school imposed a number of sanctions on him, including a prohibition on him bringing up religion in any workplace interactions thereafter. So he sued and challenged that corrective action both under the First Amendment and under Title VII, and including under this idea of religious liberty. And the court had to slice and dice this because the actual lecture that he gave, the court viewed as part of his official duties, which under the Garcetti case that Claire told you about, the government has ability to really control what its employees say when they're being paid to say things. And so the plaintiff lost that aspect of the case, or to say the university had the ability to tell him, when you give a lecture that we're ordering you to give as part of your job, you're not supposed to reference the Bible, and that restriction was upheld. But the punishment that said, in every workplace interaction hereafter, you can't bring up religion, the court said, no, I'm going to allow that claim to proceed to a jury because I think it's probably, going to prevail. Not every workplace interaction is speech pursuant to official duties under Garcetti. And this particular plaintiff has a religious belief, and in certain interactions, consensual ones, in the lunchroom or in the hallway, he wants to be able to talk about religious beliefs or the Bible or going to church, and it's too much to prohibit him from doing so at all times. That exceeds the bounds of what the institution has a legitimate interest in doing from regulating its own speech, and you don't really have a compelling rationale to burden his speech in that way. And what the court said was, it's not enough to say generally that some other employees might be offended by all of these interactions, because if that were the case, then no religious persons could ever say anything religious in the workplace, and that's not the law. So the sort of blanket ban was not upheld. And you had all these different free speech, freedom of religion, and Title VII kind of rationales tied up together in this jumble of facts, if you will. And so I think we'll see more and more cases like Faulkner, more and more cases involving the intersection of speech and religion in the names and pronouns context. This is just becoming a really heavily kind of litigated space for sure. Okay, so that kind of brings to a conclusion what we wanted to cover there. And we've got some questions that folks have chatted in. So Claire, if it's okay with you, I might just kind of pick a few of these to talk about. And so one of them that goes back to a concept Claire talked about earlier was, what should we know about the new heightened standard for true threats that the Supreme Court articulated in a case called Counterman? So this came out last year. And Counterman involved an individual who is criminally prosecuted for making threats online, I believe. And the question was, was that speech sort of First Amendment protected such that he couldn't be prosecuted, or was it the sort of true threat that falls outside the protection of the First Amendment? And what the court said was, well, when we're talking about prosecuting someone criminally, it's not enough that people reasonably perceive their speech to be threats. If we're going to prosecute you criminally, you also have to have a degree of culpability. So either you have to have intended to make a threat, or you have to have been reckless in not realizing that your speech would be perceived a threat. But if you intended or you were reckless, then you can be criminally convicted. So that's what Counterman says. It's really unique to the question of, can you criminally prosecute someone for making a true threat, which is separate from whether an employer might restrict the speech of employees that are perceived as being threatening. I think there, that sort of objective question, is it threatening or not to a reasonable observer, is still sort of what carries the day. Okay, another one. One question I've seen arise in recent days, maybe recent months, is, okay, if the government has the right to speak its own message, can that ever become coercive to the point that it sort of violates people's First Amendment rights by, chilling them, by chilling their ability to speak? So I don't know, Claire, if you have any thoughts on that one. I don't want to bogart the microphone here, so feel free to chime in on that one if you want.
Oh, I was going to respond to the Meriwether question and the economics one. I can jump in on those.
Let me take this one. Let me finish this one, and I'll go to Claire on this one. Okay, so the question is, if the government has the right to speak, can it ever speak in a way that is sort of so coercive or authoritarian that it actually violates the rights of others because they reasonably perceive the government's speech as a threat to their employment, as a threat that they're going to be criminally prosecuted? And that can happen, right? You could have the government saying, for example, as a matter of speech, we don't believe that people should be saying hateful things, and we call for everybody here to be civil. That's a legitimate expression of governmental speech. But if the government said, we call for everybody not to engage in hateful speech and everybody should be civil, and if you don't, then we are fully prepared to ring you up on conduct charges and expel you, that then becomes an articulation of sort of a threat of action that is not supported by the law and probably could get the government in trouble. So, okay, Claire, you've got a couple you want to take, so I'll turn it over to you.
Yeah. So I saw a couple comments about Meriwether, the Sixth Circuit case, and that is a really interesting case. And these pronoun cases are playing out kind of all across the country. It's a developing area of law, and Meriwether's ruling was on a motion to dismiss. So there's not much that we can take from it other than that one Federal Circuit recognized that this was a plausible First Amendment claim. So for an update on the status, somebody asked about that. After the Sixth Circuit reversed the district court's dismissal of the free speech claims, the case was then remanded for a resolution. But before the district court could actually address them, the parties settled and the case has been voluntarily dismissed without prejudice. That was in April 2022. So it was resolved before we could get any more additional guidance on whether Meriwether's claim would actually prevail over the institution's interests. And then I also saw a couple comments about the case underlying the scenario with Professor Z and the Keynesian economics methodology. That is Heim, H-E-I-M v. Daniel. And it's a Second Circuit case from 2023. And I've actually dropped the link in the chat in response to one of those questions. And that should be a public comment. So you can access that if you want to. Okay,
let me take a couple more here. someone has asked, is Faulkner's Pickering rationale, so this was the University of Cincinnati case I talked about, is that something that could be used under a Title VII analysis? So the Faulkner case was decided in 2016, back when the Title VII standard for accommodating religious beliefs was really low. An employer could say, well, if it's more than a de minimis burden, we don't have to do it. And today, we know that that standard has been raised, and we're looking at, sort of a substantial imposition. Well, the Pickering test says if an employee is speaking on a matter of public concern, the employer can only restrict that when the employer's sort of interest in maintaining order is sufficient to overcome the right to speak. And that seems like it's analogous to the Title VII standard. No court has said they're the same, but I think they both get at the point that you really need a significant degree of disruption to the employer to justify not granting the accommodation. And so in that sense, I do think there's some symmetry there. That symmetry didn't exist back in 2016, and Faulkner actually lost the Title VII claim in that case, I think, for that reason. Okay, there's another really interesting question, which is, okay, let's suppose we have an employee whose religious beliefs call for proselytizing. So the employee believes, as a matter of religious practice, they are called to proclaim their belief to other people, and let's say at all times, okay? And so this employee is constantly proselytizing coworkers while they're working, and the coworkers say, stop it, and the employer says to the proselytizer, you need to quit proselytizing to people. So what about that? How do we think about that from the perspective of a public employer that is subject to the First Amendment? How do we think about that as a private employer under Title VII and a duty to accommodate? Okay, so I guess a couple of thoughts there. The employees who are the targets of the proselytizing have a right not to be harassed on the basis that they are non-religious, and on the basis that perhaps they are of a religion different than they are being proselytized. If a person were, let's say, repeatedly subject to proselytization despite being told no to the point that it became harassment, then I think the government employee would certainly have an interest in stopping the proselytizer from going so far as to harass the coworkers on the basis that they are protected. So that could be a rationale. That could be a way of thinking about when that line could get crossed. But I also think there's a question of, okay, if an employee is constantly engaging in proselytizing to the point that they are not actually performing their job duties, they're not doing what they're being paid to do because they're doing something else, then that is a legitimate basis for the government to restrict the speech. And that's the difference between maybe someone talking about religion to a coworker while they're on lunch in a way that's consensual versus someone spending hours every day walking down the halls proselytizing instead of doing the work you're paying them to do. And there, I think the employer does have a basis. And on the private side, I think similarly, if you thought about, what is a substantial burden under Title VII, certainly avoiding a coworker being harassed would be a sufficient justification not to grant an accommodation. And someone just not doing their job because they're preoccupied with proselytizing, I think could be another one there. Okay, let me see if there's some other ones. Maybe we'll take two more, and then we want to make sure we wrap up on time and give you the rest of your day. Okay. Would you say that we're now entering a world where a religious justification for deviation from rules is not just like a most favored nation approach, but the most favored nation? Okay, so I think this comment is, and I said this, when you're thinking about free exercise jurisprudence, the Supreme Court has said if you have a generally sort of applicable law, and if it makes exceptions for various sort of secular rationales, you've also got to be willing to make an exception for someone's religious beliefs. Or you can't say that certain secular rationales are more important than religious rationales. So it elevates religion to sort of the highest level of justification for why you might make an exception. There has definitely been an increased emphasis, I would say, maybe you can call it a shift, in the degree to which the Supreme Court is policing that exception rationale. And we really saw that shift happen in some of the COVID-19 cases when the composition of the Supreme Court also happened to change. And we dealt with things like restrictions on gatherings and the size of gatherings. And then there were exceptions made for, people could go to a grocery store, but they couldn't go to church. And you saw sort of a distinct shift start to happen, and the court was more zealously protecting religious rationales. So I agree with that the law is definitely more prone to protect that now than it was, let's say, 10 or 15 years ago. Okay, last one then, and this gets back to the Kennedy case. A couple of you have said, okay, well, let's set aside the question of whether Kennedy was speaking, pursuant to his official duties. Did he really have the right to be out in the middle of a football field after the game praying? Or is that sort of a space where he didn't have a right to be, and thus he wouldn't have a right to speak? And that gets into, I think, one of Claire's slides, which said, there are certain ways of thinking about speech forums, physical spaces where speech is allowed or not. To my recollection, I don't think the district in Kennedy litigated the question of whether the field was an open forum or a closed forum. And part of the reason was the facts in that case were that after a game, basically everybody came onto the field. Parents came onto the field and met their son or daughter. Cheerleaders were on the field. The opposing team was on the field. Everybody was there sort of doing whatever. And so it would be very difficult to say it was restricted in the sense that no one could engage in religious speech. Now, if a school had a rule that said, as soon as the game's over, you clear the field, or maybe in a college setting, no one's even allowed on the field except players or coaches, then I think you have a stronger rationale that you could restrict speech because it's a closed forum, or it's simply not a place where speech is allowed. Okay. Let me give a few closing remarks here, and then we'll turn you loose for the rest of your day. All right. So obviously, thank you for joining us. We hope this information was helpful to you and to your organization. As a reminder, the program has been approved for legal education credit hours. And to report those in your jurisdiction, you need to click on the CEU icon at the bottom of your screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a link to a recording of this webinar for your future watching and sharing. Please do complete the short survey if you have a few moments. We read those. We do take your feedback into consideration, and that's very helpful to us. You can also tell us about future subject matters you'd like us to cover in our webinars, and so that's great for us to hear from you as well. So that concludes our webinar for today. Thank you for joining us.